Okay, great. So welcome committee members, liaisons, and members of the public to the Partnership Grants Committee meeting. Thank you for joining us. We're using Zoom with the goal to foster a more inclusive environment and effective meeting. If you'd like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the hosts. Alternatively, you can use the raise hand feature. In efforts of transparency for all those joining this public meeting, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you'd like to speak in order to help the chair facilitate the discussion. Note that all Trust Fund Commission meetings and committee meetings will be recorded and posted on the State Bar website. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. Just a few troubleshooting tips for those using Zoom on a computer. When on mute, holding down on the spacebar will temporarily unmute you. If you use your phone to dial into this meeting, please be sure your computer microphone is on and to avoid audio feedback issues. And while joining audio via computer is highly recommended. If an individual were to lose audio, you can call in separately using the Zoom conference number.
Would you like to take roll?
Yes. Chair Vanarelli?
Here.
Kim Bartleson?
Here.
Wilba Shelley? Deborah Myers? Chris Schreiber?
Here.
Thank you. Justice Murray?
Here.
Judge Jaskol? Sorry, Liaison Selena Copeland, Bonnie Huff, Debbie Manning, Chris Iglesias, State Bar staff, I'm present. Andrea Fatanides?
Here.
Thank you. Elizabeth Hum?
Here. And we have two phone numbers with 323, and not sure who they are, so should we allow them to introduce themselves?
Sure.
Okay. So folks on the phone that are calling in from a 323 phone number, you've been unmuted. I think you might need to unmute yourself if you want to introduce yourselves.
Maybe they don't want to.
Okay.
Is that okay?
Okay, great. Pastor Christina, we do have quorum for today.
Excellent. Now I will inquire if there is any member of the public who would like to make a comment about any agenda item. Okay, hearing none, we will move on to item 3 of the agenda, which is to approve the meeting summary and action items from August 11th, 2020.
Bartleson moves for approval.
Okay, is there a second?
I'll second.
Okay, any further discussion? Hearing none, all in favor? Oh, I'm sorry, wrong board. We'll have a roll call vote.
Thank you. Vanarelli?
Yes.
Bartleson?
Yes.
Bishali? Myers? Schreiber?
Yes.
Okay, perfect. Passes by unanimous.
Yes. Okay, we'll move on to item 4, which is discussion and action items. We're actually going to take these a little bit out of order because I understand Kim Bartleson has to leave early. So we're going to start with item number 4C, and Crystal's going to present that item.
Great, so there is an agenda item attached to, there's a memo attached to this agenda item on the posted agenda. So I'll give a brief overview of this. So this is item 6C, review and approve recommendation regarding Santa Clara Laws, Katherine and George Alexander Community Law Center's 2021 partnership grant. I'll be referring to them as Santa Clara as we go on. It's a very long title. So just to provide a brief update regarding the 2021 partnership grants, the committee met on August 11, the commission met on August 14, and the Judicial Council met on September 4th. Following those meetings, 35 projects were approved for 2021 partnership grant funding for a total of about $2.4 million. So during the course of a Senate monitoring visit in September, it was discovered that Santa Clara's 2021 proposal did not get reviewed by the committee due to a technical error on Smart Simple. When staff looked into the issue with Smart Simple, it appeared that Santa Clara's application was miscoded as a 2021 application and therefore not included into the 2021 list for review. Smart Simple later attributed that issue to the miscoding to a cache issue, and I guess that's how that was the conclusion that Smart Simple came to. So the memo kind of describes how how staff, as well as the review team, worked to remedy the situation and the steps we took. First, staff notified Chair Vanarelli, as well as Bonnie Huff from the Judicial Council of the error, and looked into the application. Santa Clara did submit a timely application before the March 16 deadline. And because the error did not appear to be Santa Clara's fault, we proceeded to review the application. Just to ensure parity into the review process, we mirrored the 2021 review process, but on an expedited timeline. Santa Clara was first provided an opportunity to revise their application to reflect any updates regarding COVID-19. And then we also formed an ad hoc committee with Chair Vanarelli and Chris Schreiber to review the application. Because this project is in its 4th year of funding and no projects in 2021 received reduced funding, that was not a recommendation. I forgot to mention that Santa Clara's project was requesting $60,000. And because those funds from 2021 were already dispersed, we have identified reserve funds to cover that funding. Another consideration was that in 2021, all projects received about a 1.89% decrease. It was that haircut that we gave at the end. And so Christina and Chris both thought it'd be equitable to give Santa Clara the same decrease in amount. So here's the proposal, and should it get approved, the next steps that would happen is that Judicial Council would bring the Santa Clara recommendation to its January 22nd meeting. And then similarly, Santa Clara would have to do a budget revision, as well as provide documentation before any funds are released.
Are there any questions? Okay. So we are requesting a motion to, as stated. Okay.
Move for approval.
Well, I'll second this one. Hearing no further discussion, we'll have a roll call vote.
Sure. Vanarelli?
Yes.
Bartleson?
Yes.
Bisheli? Myers? Schreiber?
Yes.
Okay. Fantastic. So the motion is approved. This memo, as you can see, it was addressed to both the committee and the commission. So this same memo will be presented at the commission meeting at 12 o'clock. I'll provide an overview during that meeting as well. Thank you.
Okay, now we'll move on to item number A, an update regarding the 2020 partnership grants, and that'll be presented by Elizabeth.
Hi, good morning, everyone. Just a really quick update on 2020 partnership grants that are underway. We still have 4 outstanding memorandums of understandings between the court and the projects. They are all Los Angeles-based projects. So we have reached out to Bonnie at the Judicial Council and she's aware of the situation. And she's been in touch with the LA Superior Court to see if we can move those MOUs along so that we can receive all the documentation and release the grant agreements and disperse the funds. So we are hopeful that this will happen in the next couple of weeks so that we will do this before year end.
Okay, are there any questions on that? Thank you.
You're welcome.
Agenda item 4B will be presented by Crystal.
Thank you. So just wanted to remind the commission, this was the recommendation approved by the Trust Fund Commission and also discussed by the committee previously back in June. This basically permits grantees, partnership grant applicants the opportunity to request carryover and budget revisions for their 2021 grants. The deadline for grantees to submit such requests is November 20th, which is why we are seeking an ad hoc meeting in December to just review any grants that require committee review. So similar to the IOLTA and EAF process, any budget revisions or requests below 10% are immaterial. 10 to 25% staff will have the ability to approve, and anything above 25% will need to be reviewed by the committee and the commission. As of today, we have not yet received any requests, but if it is similar to IOLTA and EAF, we probably will be receiving requests much closer to that November 20th deadline. So just speaking of the ad hoc meeting, we just wanted to confirm the times and days. I know we sent a doodle poll out a few weeks ago, and it seemed that Tuesday, December 1st was the best date that worked for everyone. There's been a few scheduling updates since then. I just wanted to confirm if we can get consensus on these proposed times on the screen, just so we can kind of iron out that date and just put it on the calendar.
I can do any of those times.
I can do the first and the last, but not at 11.
Okay, great.
I am up in the air. I can try to do the 10. It may be only call in though.
Oh, that's fine. That's fine.
I'm good for all those times.
Okay, perfect. So we'll set it for Tuesday, December 1st from 10 to 11 a.m. We'll just get on everyone's calendar as soon as possible. Thank you. So as a reminder, this ad hoc meeting will be to discuss any budget revisions or carryover requests, as well as the proposed rubric, which we'll talk about upcoming in the agenda.
Let's talk about that now.
Sure. So just wanted to note for this agenda item, it says to review and approve proposed rubric for the 2022 partnership grants. Just in the course of preparing for this meeting and reviewing the rubric, what we're going to have instead of approval is to have a facilitated discussion and get the committee's feedback on the rubric the preliminary rubric and proposed rubric that staff has developed. And we wanted to get your input. You know, you're very close to these proposals and you review them. So we want to ensure that it's reflective of that process. So first, just wanted to give an overview of what we hope that this is the goal and that the rubric will accomplish. The first thing is to first and foremost provide transparency to applicants and clarity to the partnership grant committee members, both during the application and the review process. We also want to ensure equity in the review process, as well as streamline and align the review process with the State Bar's other discretionary grants, which are bank grants and the HP grants. In terms of existing authorities and policies, there's really just two authorities that dictate like the regulations and the requirements of the partnership grants. That's the State Budget Act, as well as the approved grant policies that were approved in 2018. We did want to note that, as you know, policy changes will be addressed during the codification process. So the proposed rubric will not recommend substantive or changes to the existing policy. So with that, I'm going to go ahead and share on the screen the layout of the rubric and kind of what our thoughts were and thinking about this. We looked at grants rubrics online from private funders. We're also going to take a look at other state entities just to kind of see what they're doing, but this seemed to fit the requirements of the partnership grants the best, and we'll looking forward to the feedback. So what we're proposing is a kind of a three-pronged rubric with the first kind of prong being the eligibility requirements. So since these are threshold eligibility requirements, I think we're envisioning a yes/no checklist. And if there's any no's on that checklist, the project would be ineligible and not be considered for grant funding for that year. But if the project is eligible and meets all the requirements, self-indigent person, self-represented, at or near the courthouse, we would be moving on to prongs 2 and 3. The second section would be funding priorities, and we are proposing a scoring of 1 to 5 based on the existing funding priorities. So as a reminder, funding priorities the priority goes to new projects, as well as any projects over 5 years that serve rural areas or responding to a recent emergency or disaster as per the current authorities. So I think we do have a multiplier in there for a total possible points of 25. So it'd be, I believe it's 5 times 5 and it'd be 25. So moving on, the next area would be the selection criteria, which is currently listed, I believe it's like 8 bullet points on our RFP and existing documentation, but now we would be proposing to change that into kind of a, it'd be the criteria and then 3 columns of exceeds expectations, meets expectations, and needs improvement. So instead of individually rating their criteria, it would be according to those 3 categories, and then you would tally the bottom, also with the multiplier for a total possible points of 75. So all in all, the reason why we have the multipliers is that it rounds out to a nice number of 100, which is the total of the funding priorities in section 2, as well as the selection criteria in section 3. Okay, I can slow that down or describe anything else if that didn't make sense. I know there's a lot of numbers and multipliers, but I guess, are there any initial questions at this point?
I have a question, Crystal. On the selection criteria, I imagine most of the programs are going to be in the meets category, but how is it exceeds and needs improvement going to be defined, or is that something we're going to just do by feel, essentially, like we've always done these, or is there some specific criteria or definition of those categories?
So, so not currently. This is just kind of like the bones, like the outline. But I think what we'd want is to get committee feedback for the committee to define that criteria before it becomes like an individual interpretation, because we are trying to just streamline it and everyone has the same understanding of what exceeds means and meets means and needs improvement. So yeah, that's a good idea to just kind of clearly define it. And I will be reaching out just for additional feedback. So yeah, that's great.
And I just also want to add that this rubric looks a little bit different. If any of you have been involved with bank grants or the homelessness prevention funds, it does look a little bit different. And this was developed with kind of what we've found in using those rubrics. And to your point, Justice Murray, for currently with the HP RFP grants, we each working group had a calibration session. Well, staff had a calibration session, and then each working group had a calibration session so that we could make sure that we were all kind of using the same definitions and reviewing similarly. We didn't want, somebody who was like a quote unquote tough grader or an easy grader to, sway the rubric scores. And so that we will definitely build in that calibration session before the review process begins.
Thank you.
Okay. So I just wanted to ask a couple of discussion questions and just get the committee feedback. First, I just wanted to get any initial feedback on the proposed 3 categories, as well as the approach that we're taking to the rubric, if there's any other ideas or thoughts on that.
I think Crystal and I have discussed this rubric at length, and I think we all appreciate the goal is so that we're consistent with all of the projects. And I just, I want to make sure that the math comes out right, that we are prioritizing. And I can't tell just from eyeballing that if that's the appropriate formula, but I think the idea is excellent and it's needed. So that would be my concern, that before we implement this, we do what we can to make sure that the math is going to work. And I don't know how we do that.
I mean, that could also work with maybe looking at like 2021 grants and then ranking those and seeing how it kind of, what the result is using the math and kind of calibrating it that way.
That's a good idea.
This brings me to my second question about the appropriate weighting for funding priorities, because right now it's at 25% out of the 100. I don't know, like in terms of important, I mean, everything is important, but in terms, does that would it be more appropriate for funding priorities to be higher, like 50%, or is that too high? In terms of how you approach these partnership grants, like what's most important?
So can so I guess I have two thoughts. One is, there's sort of two, as I understand it, two driving motivations for this. One is equity, and two is efficiency. Is that fair?
Yes.
Okay, so I guess I haven't, and maybe I'm obviously open to being corrected on this. But let me say, I wasn't aware that anybody had said there was anything inequitable about how the outcomes have turned out in the past. Am I wrong about that? I mean, it feels like that isn't a huge concern in terms of.
So there wasn't any specific instance or feedback that we received that the process was inequitable. We did receive a directive from the Board of Trustees in 2019 that all of our discretionary grants should utilize a rubric so that there's transparency and clarity both for the grantees and for the commissioners when they're reviewing the grant applications. So we're moving this forward also in response to that request.
Yeah, okay, so that's helpful. And so the efficiency, I think, okay. The one thing I guess I would say, as somebody who's been doing the partnership grants for a few years, Justice Murray, Christina, I think you may share this perspective, but I won't speak for you. But that if anything, the partnership grant proposals have tended to sort of fall into, I don't know, like a little bit of a rut, in the sense that they've, for lots of different reasons, they address needs, but once those needs are identified through partnership grants, like our policy discussions have sort of focused on innovation and how do we inspire innovation and whatnot. So I guess to me, the rubric privileging new ideas or privileging some sort of innovation or the delivery of services in a new and innovative way is somewhere we should look and sort of press the courts and the programs to be thinking. That's not really in either of the two silos, though, is sort of my point, which is that's not really an equity issue, and that's also not really an efficiency from the perspective of the staff and commissioners who are on this committee. So it's sort of a different issue. And I'm not sure the rubric will address that, but it does seem to me to be sort of where we focus.
So Chris, do you think maybe we could set up a third silo for innovation and give additional credits for something that's truly innovative?
I mean, I think in terms of what this is just how I'm thinking about it. What we've spent our hours and hours in this committee. This is a very labor-intensive process, as everybody knows, for this particular subcommittee of the commission. And so I'm all for the efficiency. Hooray, let's do that. The equity piece, to me, I understand it's a directive from the bar, but I just want to be clear, it's not really addressing anything specific in way of complaint or an outcome. So, kudos to the staff and commission that's been overseeing this over the years. The thing that, to me, the shortcoming of this sort of part of our funding stream is that these grants have really been sort of frustratingly locked in a lot of ways. And I want to just be clear, that's not really finding fault, because a huge part of this is that the courts themselves don't really have the staff or the time necessarily to like be thinking, you know, about this. It's like they're putting out fires, and so I think what happens is the courts are like, look, 90% of this paperwork is messed up. Can we please get a little bit of a hand here on this? And then a program dedicates some resources through a partnership grant to sort of address a specific need. And I guess I just feel like our policy discussions have been sort of around that issue, around like, how can we create new efficiencies that aren't putting out fires, but that actually are anticipating and are sort of ahead of the curve. They are less reactive and more proactive. So to answer your question, Justice Murray, I guess I'd say to the extent that we are going to make funding decisions based on the pool that we've received in the past, I don't really see us interrupting that. But if we're trying to signal that we will give more money, or that you could get less money if you aren't innovative, then we could certainly be signaling that through the rubric.
I had some thoughts too. So another piece in terms of 2022, because we are looking at the whole process, are the grant evaluations and that evaluation piece. I think just in general, like my experience on the committee is that the evaluation, like it is a component, but I feel like there could be more emphasis, and we are looking to provide more clarity in terms of like how effective is this project, besides, you know, in addition to the application. So could we also address some of those questions and concerns and get more information through like a revamped evaluation?
Yeah, you know better than me that the challenge of evaluation work, or the challenges, are really profound for lots of, and in part because of all the various reasons that we've talked about so often. But for example, you know, one of the big challenges that comes to mind is that what might actually address a really serious issue in a particular county court, and is specific to a specific court, it may well serve fewer people than some big impact program in another court, but that court doesn't have the problem. So, you know, like conservatorships in particular counties, that's like an issue, and it's not an issue in every county, or it's not one that is being prioritized in every county. So I don't know, I'm with you on that, Crystal. I think like, yes, figuring out ways to evaluate is always a good idea. But it is, I think we've found that like the sound discretion of experienced staff and commissioners is probably the best way to do these evaluations on our end, and on their end, sort of same thing. Courts, judges, staff, and program managers. Anyway, I don't know that that changes our course at all. That's just my thoughts on the rubric.
You know, I kind of like the idea of motivating innovation by our point system. I think we could consider adding bonus points maybe, or something like that. I would not necessarily advise that we offer fewer points or subtract points for a lack of innovation, for a couple of reasons. One, you know, in terms of what courts do and are able to do, I mean, we've sort of evolved this process to a point where pretty much everything that courts might be able to do relative to self-represented litigants has been covered somewhere in the state. So I don't know how much room there is left for innovation on any particular area. And another reason is for Chris, consistent with what you just mentioned, particular courts have particular needs, and a program that might be new to a particular court to address those needs might not necessarily be particularly innovative in the sense that it's something that's been replicated from somewhere else, but it would fill an existing need in that particular court. So I wouldn't want to see us penalize courts for not showing innovation, but maybe consider that from a perspective of giving bonus points or something like that.
I like that.
Yeah, I agree.
We have a comment from M4C Zoom, so I'm going to unmute them if that's okay.
I am logged in on my wrong account.
I'm sorry, Will.
Let me log back in. I'm sorry about that.
Oh, it says Kim also has a comment.
Along the lines of the conversation on innovation, one of the things that we experienced when we were looking at some of the grant proposals was, I believe that I shared, there were some innovation grants done under a different funding source through Judicial Council that some courts had done where it was on a regional basis for conservatorship classes and different things like that. And if there is a way that somehow we could, I guess maybe have a inventory that would be a resource for grant applicants to look at other counties if there's something that's already in place along those lines so that we're maximizing. In the remote areas, there's less likely an opportunity that all needs are being met. So if there's a way as part of a jurisdiction's creating a program that it could be mimicked virtually to allow sharing statewide, that would be very beneficial. And I agree with extra points in the situations where innovation is included as a component of what they're developing.
Welcome, Will.
I actually was on the call the entire time. I couldn't figure out how to unmute myself apparently because I called in. So technical difficulties abound. So sorry for the confusion. I had a couple remarks on what I've heard. This looks like a very good start to the rubric discussion. And in terms of inequity, I think the only thing that I've seen when going through this process that the eligibility as stated in the documents that I reviewed didn't seem to quite match the reality. So there's a 5-year limit, for example, on programs, but modifying the program allows it to be considered as new. That's something you would only know if you were involved heavily or received that information. I think there were a couple other examples where the eligibility seemed to have some room. And I think the one concern I had based on what I heard was the yes, no of that process might not reflect the reality of at least how funding decisions have been made in the past. It's okay to make that change and be more restrictive, but I think we need to commit to that and acknowledge that it is a change. Let's see. And then as far as I think on the back end, I definitely would really like evaluation of the services provided, especially from the perspective of the people who are receiving the services. I know this is challenging for so many reasons, but it is something that I looked at in each of the grant proposals I reviewed, and the information was always lacking. I don't know that the services had the ability to really engage all of their people in a way, all of the people they were providing services to in a way that allowed them to get that feedback. But I think that is lacking, and it's especially important in evaluating how effective these funds are being used to know what the results are like from this perspective of the people who are getting the services. So I'm not sure how that would fit in here, but I would like that to be further discussed and added. And yes, I wanted to answer the question here for the needs improvement on this slide. I think because I don't believe we're acting in an adversarial basis, we want to collaborate and provide oversight, absolutely allowing them to address items and learn and grow, I think is an excellent opportunity. And then I have one last consideration, which may be dismissed out of hand because it's going to add work. But I think whatever rubric is developed, it would be very interesting to see a simulation of the grantees for 2020, how they would come out versus the reality of what happened. That may be too much work, but if we're committing long-term to this sort of rubric, it's probably worth it. If it's something that we are going to be able to adjust as we see the problems kind of shake out, then that's less important to me. But I'm not sure how long we're going to be committing to it. And if it is a long commitment, I think we really should understand how it's going to be applied in the real world.
Hey, Will, what did you mean by that last point in terms of how they would come out?
Oh, in terms of the funding that they would receive or whether they would be eligible.
Compared to what, though?
Compared to the reality. So for the 2020 grantees, I'm talking about the ones that we've already done for this year. We've already issued the allocation, or said what the allocation, I guess it's 2021, aren't I? Sorry, I'm getting the years confused. But the last year that we've completed, where we've set the allocation and determined eligibility, applying the rubric to that evaluation. Does that make more sense?
Yes, meaning retrospectively apply the rubric and see if it would make a difference.
Yes.
Got it.
And understand what that difference would be. But again, it kind of depends on how long we're committing to this rubric. If it can be adjusted on a yearly basis to take into account real world experience, then I don't think that's necessary. If it's going to be difficult to address or to adjust, then I think it would be really useful in terms of evaluating it.
We could at least do
I think before we put this rubric in place, we should at least take a sample of the most current grant year projects and plug in the rubric to see how it would work, because that kind of fine tuning could be done up front as opposed to waiting to this current grant year to see that we need to fine tune it. I don't know that we need to go through all of the 2021 grant applications. And I'm not even sure that would be yield much more productivity than just taking a sample. But maybe we should just select a few. How we make that selection or what programs we select, I don't know. I think we have to take some care in how we do that, because that could sort of skew, the outcome of plugging in the rubric. I don't know, maybe just do it randomly. Put them all in a hat and pick them out one by one, or do it by the size of the courts. I'm not sure. We need to take some care in how we made that selection, but I don't think we need to go through all of the programs.
I agree, Justice Murray. That's an excellent point. A random sample would be more than adequate.
So Will, just to address your question of, how long are we going to stay with this rubric? So all of the discretionary grant processes and rubrics will be evaluated during the codification process. I don't have at my fingertips what that calendar is right now, but it will probably be either in late 2021 or early 2022, where we'll be looking at all the discretionary grants and rubrics. So what we're trying to create for the 2022 partnership grant review is a rubric just for that year. And obviously, you know, I don't know if you heard earlier when we're using a rubric now for the HP RFP review, and we're learning a lot just using the rubric on that grant side. And so I think, you know, having a cycle using a rubric for partnership grant will really inform the codification process. So there's definitely room to tweak and adjust as we're learning more and getting better at this.
Fantastic, thank you.
Mm-hmm.
I think Kim had did Kim have a comment?
I had previously made it, unless you couldn't hear me.
Okay. Nope. I just saw it in the chat. I didn't know if that was new.
But I do have one additional thought. One of the concerns that I've had with the grant applications that have been essentially rolling over is the fact that we are frequently, without any modifications, seeing requests come in to extend into years 6 and 7. And I don't think we're serving the entire community in the best way if we're having that happen. So I just want to put it out there. I think that we need to possibly talk through it a bit more, because if we're trying to expand access to the courts in the community, it has to be statewide, not just in one area.
I mean, my take on that, Kim, is that we've generally, that has been a function of our bleeding hearts. So if there is a hard and fast rule, then you won't, and I'm not against it, by the way. But if there's a hard and fast rule, you won't get the application. So there is a benefit to having you know, a literal rule that just says, like, don't apply, because it is not possible for us to give you money in a, whether it's a 6th, 7th, or 8th year. When those arrive, we've basically said, look, there's no other funding source or whatever. We've talked ourselves into them in order to basically not cut off services, and typically in rural areas.
Yeah.
But yeah, I hear you. I guess I would, my only response to that is, I think the only solution there is a rule that doesn't allow the worst of our best angels to come out. So
true.
Or the best of our worst angels, whichever way you put it.
You know, some of that is kind of a function of how much money is available also.
Yeah.
So in leaner years, obviously, if program's been up and going for a long time and it's not one of the exceptions, like a rural area serving underserved communities, you know, we would probably give that program a haircut, or maybe even considering not funding it. But when there's money available and we can give all of the worthy programs funding that's close to their request, you know, I don't see any reason to arbitrarily withhold money from programs, even if they've been up and going for a long period of time. But if we're going to move in that direction, we need to send a really clear signal to the providers that this is going to be what it is in the future, because I think there is some measure of reliance that they've become accustomed to. And you know, you just don't want to surprise folks by saying, oh, sorry, you know, we're not going to give you more funding because you're in your 6th year, when we've been doing that all along. And they may have been, you know, sort of relying on that money coming in and not looking for additional funds as hard as they should have. You know, it's kind of a balance that we have to make, because we should be encouraging them to look for additional funding, but you know, the way our state's been going over the country has been going over the last period of time since I've been on the commission, you know, it's just such a roller coaster, and the availability of funding kind of goes up and down, and it's not up very long when it's up, it seems like. And, you know, we should be able to accommodate for that, even if a program's been up and going for a substantial period of time.
When I first joined the commission years ago, we were much stricter in applying that 5-year rule. And the result of that was that some good programs, rural programs, had to go out of business essentially, because we just cut them off. And so I think gradually over the years, we've been getting a little more lenient, recognizing that if there are good programs providing services that people need and they can't get any other way, as Chris said, the bleeding heart in us wants to fund those programs. And so that's the path that I've observed.
Can I ask, the priorities for the partnership grants, that's set by statute or the Board of Trustees?
I think the commission.
Yeah, the commission set the priorities.
Oh, so we could say that, go ahead.
But any policy changes at this juncture would need to be approved by the Board of Trustees. So that's why for this rubric, we're asking that no policy changes be made, and that policy changes be really looked at through the codification process.
Right. I guess the challenge is we're the seesaw effect of saying, well, we're going to be strict because these are the rules as they exist now, and we're just codifying them. We're not changing them. But then maybe we will be discussing changing them to allow for the reality of the situation, which is that some of these programs are dependent on this funding, as I understand it. Huh, that's disappointing, because we're gonna have to go through that big hoop of working on a rubric and then finally get to discuss, hey, maybe we should change the priorities for this particular grant program. Rather than try and, I'm not sure the answer there, but I'm concerned about that process.
This is Kim again. One of the things I threw it out there because we're not going to change it instantly, and I don't see us changing it in the next 2 years. But based on, I think this is my 4th cycle now in reviewing applications, Justice Murray had the reliance upon, or the expected reliance upon the grantees that they will get money in some form from us. I think that in the bigger scope, we need to look to the future and really reevaluate what our historical practices have been, and come up with a methodology that does not leave them with the expectation they're going to get it if they ask for it, even at a reduced amount. So I struggle with some of our touchy-feely meetings that we've had, even staying on the commission, because I am accustomed to, you apply for funding, you have reporting requirements, and you do what you're supposed to. And I don't see our grantees necessarily always doing that. And we for the sake of programs and the community that is the beneficiary of the funds, we move forward. But it's been a struggle for me because of working in the governmental accounting grant environment for 26 years. It's what we do is inconsistent with auditing practices and everything else. And I just think if we're going to have a more robust program and reach more people across the state as far as getting services available, we need to put it out there and not look in the next 2 years for it being resolved, but come up with a different approach to change expectations, make them, the grant applicants, seek additional funding, and just a different approach to it. I agreed to stay on the committee because of COVID, and so the chief reappointed me, but I had some pretty extensive conversations with Bonnie Huff, just because how lax I felt that we have been. And we're not there's still pockets that we benefit greatly, and there's other parts of the state, for lack of maybe having the ability to have an entity apply for grants, that's not receiving any benefits. So put it out there. I think it'll be a much more extensive conversation and some different thoughts that we need to, and knowing that it's not going to be resolved in the next 2 years.
It can't be resolved in the next 2 years because of the restriction on policy changes? Is that?
And I think there's some nuances, I think, that we need to really look at in all of our methodology on how we approach it, how we disseminate it. I think that we should be doing some sort of webinar trainings as we put these applications out. That's a big gap for maybe somebody applying. In Northern California, for example, there's really not a lot of opportunity in say Humboldt to apply, but maybe on a regional level there might be. So there's a lot of different approaches that we should be looking at. And the more that we're able to have the money be serving more people and more communities, I think that we're achieving what we want to achieve with the funds.
Yeah, that sounds like an ideal to me. I hearing that explanation of how it could work, and feeling very strongly that our documentation should align with the reality of how we're going to assess these providers. It feels like the rubric is the cart before the horse.
It could be.
What?
Go ahead, Bonnie. Sorry.
Hi. So, I think one of the other challenges that we've had, and I think you're right, Christina, that we used to be very clear that it was 5 years, and then determined that we needed to make an exception for the rural areas that really didn't have the opportunity to get additional funding. And I have in the past reached out to legal services providers in the North. I mean, frankly, to legal services in Northern California to say, is it possible that you could take on some other areas? And I think that is sort of one of the challenges. And it seems like it might be worthwhile this year to really, work with you, Kim, to say, can we reach out to court execs or other folks and figure out a more of a regional approach? Because I think it is hard for many courts to do that, or for LISNIC as the only legal services provider in that area to take on a huge number of projects. And right. Similarly, we have that challenge in the Central Valley. But to really think that through in a new way, because I think all of us, rural is clearly an area where, I think all of us really see a need for services and sort of thinking how to do that. So, I mean, I would be delighted to work on a sort of systemic outreach and really think this through and start it early enough that people have more than a month or so to come up with a proposal and do the meetings and all that kind of stuff, because it's not easy to, particularly if we're doing a multi-county approach or, some other kind of approach. But I mean, I'll just say the project for the mother load, has always seemed to me a very strong project, a very strong collaboration. And, it is very, very hard to find funding in those areas.
Right. And then the innovation grants that facilitated a number of different projects. There was one that Butte took the lead on as an example. And I believe there were 13 courts that were in partnership on that. But the result was the ability for essentially virtual classes for pro pers to be able to have somebody to answer questions and walk them through preparing different kinds of paperwork. And it's that, again, I expect we will continue for a period of time to see funding be restricted as far as what we have the ability to allocate. And if we're going to better serve the increasing number of pro per litigants with resources, I liked how that turned out, but it's going to be, we need more than just Bonnie and myself to work on it. So anybody else that wants a challenge on how we could become more innovative and improve access, we would welcome the support.
I'm down to help out, however.
Awesome.
If I can. and I really like what's being said here. I would like us to make sure that our policies and procedures, especially a rubric, matches the real need and that we clearly have. There's greater understanding on this committee than I have, and it would be great if we did that prior to spending all of the staff time on the rubric. Though clearly this work will be needed in the future, so it's not a waste of time. But I do have that concern.
You know, I don't want to react. I agree with much of what you said, Kim, and I don't want to react defensively to it. I guess because I think you're expressing an ideal that we should be striving for. The one area I might push back, though, is to say that there's been some, and I'm not sure this is what you meant, but I guess I would, to the extent you did mean it, I would disagree that there was some sort of accounting or some sort of policy or approval irregularity in the process over the last few cycles or however many that your comments were related to. I have not experienced that. I guess so the one thing that it sounds like the way I hear you on this is that the commission and this particular committee are dealing with what we are presented. And it sounds like the critique is, at least in part, about what we're presented, meaning we are presented everything we could be presented. And maybe the reason for that is that there are structural barriers to the ability of programs or courts in underserved parts of the state, and to use the Humboldt County example, that are preventing them from entering the discussion. But I certainly haven't experienced us as being discouraging of that process or in any way discriminating against those programs. And I guess, I share the view that it'd be great to spread these services out in the most equitable way. But I think, as Bonnie pointed out, like our challenge is that, we aren't necessarily presented with perfect equity in the applications that do come in. And maybe that's just a structural problem.
Thanks, Chris. I appreciate your comments, and we have to talk through things, and each of us has our own views, and I take no offense to it. So please be candid, and I do appreciate it.
Is there any further discussion on this item?
I guess other than, is there an alternative in terms of the workflow here in the work plan, or are we committed because the higher ups say this is the way, this is the path?
There is a directive to have a rubric. I don't feel like it's negative. I don't feel like we should frame it negatively. I think it is actually a good step one in a long process to really look at the partnership grants and kind of take all of the feedback you all provided today and improve the review process in the future. And I think definitely, for 2022, this will be a rubric that may not address all the issues and may not address all the policy concerns. I mean, it won't address the policy concerns, but I think it's a good step forward, and we can learn from it and take that through the codification process to really develop something useful and innovative and transparent and equitable through the codification process.
Okay, thank you, Elizabeth.
Does anybody else have any comments?
I just wanted to add on to, you know, because it is a director from the Board of Trustees, and the timing, I know this is for 2022, but we do release the RFP in January. Now, this is why we're having an ad hoc meeting in December 1st, which is not too not too long from now. I know we have the Thanksgiving break as well. I guess I just wanted to get consensus from the group that this is the right direction. We just need to tweak, maybe do some beta testing on like a 2020 proposals that we looked at already and kind of move this forward. I just wanted to get consensus with the committee at this point.
Can I raise an issue about addressing recent emergency or disasters? And I apologize that I had to be on phone. I couldn't figure out how to get into Zoom earlier. But given the fact that people apply in March and won't be getting the funding until January, I think, you know, addressing recent emergencies is sort of difficult. And I mean, that said, I suspect we'll have a whole bunch of people that will be applying to address COVID, right? And that may be pretty straightforward, or fires or things like that. But it feels like I'm a little cautious about that because this is not a nimble grant, right? This is not a, oh, the fire, you know, the fire happened in December and okay, you'll get assistance in a year. And, you know, sometimes that's helpful, but sometimes that isn't exactly addressing what needs to happen at a given time. So I'm a little cautious about that. I think we had initially added in information about emergencies and disasters because we knew that that really impacted fundraising capacity for programs. I think that came up, you know, like with the San Diego fires years ago, like they weren't going to be able to do big, their gala was not happening, right? And we know that those kinds of things happen, but I'm not sure. And again, maybe it will be different because of COVID, but the kinds of things that people can do as self-represented litigants and the kinds of things people do in the court setting related to an emergency may not entirely match. Mm-hmm. And so I'm cautious about that. You know, maybe it's, I don't know. I mean, I guess, so I'll just speak to this a little bit. You know, custody can change. Obviously housing changes, but again, that the housing issues feel like they're way before a year from now, and particularly if you're starting a new program. So anyway, it's not my favorite of the things to look at.
Yeah, thank you, Bonnie. So I think that language is actually pulled directly from some of the policy documentation, which we'll take a closer look at. Okay. I think we do have some flexibility and latitude to kind of look at that selection criteria. Just kind of, again, reminded like there's no policy changes, so we are kind of working within given parameters. So maybe that's not the right wording. I think we do have some flexibility to kind of reword it to be the intent of what that meant. So yeah, thank you for bringing that up.
All right, is there any further discussion on this? Okay, does anybody have anything else that they wish to talk about before we adjourn? I would just like to thank State Bar staff. It's been a great pleasure working with Crystal especially, and they've really done a lot of work. Look how early we're done. It's because that they have fine-tuned everything. So I really appreciate all of your work. And with that, we will adjourn and see everybody at noon.
Thank you.
Thank you.
Thank you all. Thank you, staff. Enjoy your 55 minutes. There,
Thanks all. See you later.